Assalamualaikum. My name is Nur Kamarina binti Muhammad Zainuri. My metric number is I18303399. Today I would like to present about Chapter 7, Settlement of Trade Dispute. Okay, my part is settlement without state intervention. There are two ways in which the basic parties to an industrial dispute between the employer and the employees that can settle their dispute. First, collective bargaining. Second, voluntary arbitration. Collective bargaining. Collective bargaining is where a group of employees get together to negotiate better terms with their employer. A collective bargaining agreement usually cover items such as pay, benefit, working condition, and pension. Step of collective bargaining. Collective bargaining involves the following main step. First, presentation in a collective manner to the employer of the employees' demand and grievances. Second, discussion and negotiation on the basis of mutual give and take for settling the grievances and fulfilling the demand. Third, signing of a formal agreement or an informal understanding when negotiation result in manual satisfaction. And fourth, in the event of the failure of negotiation, a likely result to strike or lock out to force the recalcitrant party to come to terms. Type of collective bargaining. Dispute bargaining. Dispute bargaining is a competitive bargaining strategy in which one party gains only if the other party loses something. Second, integrative bargaining. Integrative bargaining is a negotiation strategy in which parties collaborate to find a win-win situation to their dispute. Third, productivity bargaining. Productivity bargaining is the process of reaching an agreement through collective bargaining whereby the employee of an organization agree to change which are intended to improve productivity in return for an increase in pay or other benefit. Fourth, composite bargaining. Composite bargaining refers to a negotiation that focuses on a number of elements that are not related to pay. And lastly, concessionary bargaining. Concessionary bargaining is a term used in labor law. It is a kind of collective bargaining in which the trade union surrender or give back previously gained improvement in pay and condition in exchange for some form of job security. Okay, last but not least, voluntary arbitration. Voluntary arbitration means the procedure whereby parties involved in an labor dispute mutually agree to submit their differences to a third party for a final and binding decision. Okay, first, pre-dispute arbitration. A contract between parties may contain an arbitration clause. This agreement requires that any dispute over the contract will be arbitrated. Okay, next, post-dispute arbitration. The party may enter into an agreement after the dispute arises to resolve a dispute through arbitration. Okay, that's all from me. Thank you.
Assalamualaikum warahmatullahi wabarakatuh. My name is Siti Nur Ashiki binti Abdusman Kamaruddin. Today I will presentation about settlement under the influence of the state. Okay, the principle and smooth functioning to industrial relations is of vital importance to the community. Interruptions in production because of strike and lockouts cause untold inconveniences and loss of economic welfare to people in general, especially if the supply of essential goods and service is stopped. The changing nature of strike and lockout involving entire industry has further strained the need for interventions by the state in the settlement of industrial disputes. The underdeveloped countries which have a large vast programmers of economic development and have adopted the system of planning find that they cannot afford frequent interruptions in production. Therefore, there is a growing tendency on the part of the state to intervene and to seek to promote peaceful way of settling industrial disputes in both the industrial developed and underdeveloped country. Okay, the most common way in which the state interventions take place are the following. First, compulsory establishment of bipartite committee commits. Second, establishment of compulsory collective bargaining. Third, conciliations and mediations, which is voluntary and compulsory. Fourth, compulsory investigation. And last is compulsory arbitrations or adjudication. Okay, next about compulsory establishment of bipartite committees. It is well known to students of industrial psychology and bad economic stats. Apart from these conflict issues such as salaries and working hour bonus, pensions, gratuities, and other, there are many more industrial grievances which, if the answer accumulates and grow into a large industry, ultimately threatens internal distribution product. Therefore, the state has passes an enactment requiring the establishment of a bipartite committee composed from representatives of employed and their employed at the plant or industrial level. This bipartite committee is empowered to resolve differences between employees and employer as soon as they appear, and thus prevent them from developing into large fires. A work committee consistent of representative of the works and employee and is entrusted with the responsibility to promote measures from securing and preserving amity and good relations between the employee and the workman, and to the end to comment upon matter of their common interest or concern and endeavor to compose any material difference of opinions in respect of such matter. Okay, for section 3/2, the relevant rules framed by the central government under this act lay down the detail concerning the size of work committees, the selection of workers, representative, terms of office, facilities for meeting, and so on. Okay, next about the state government have framed similar rules requiring the formation of work committees in different industrial establishments. Some of these work committees are functioning successful and discharging their functions in a responsible manner, but most of them have proved to be a failure. The main factor accounting for their failure have been the reluctance and hostility of the employee or the trade union concerned. Second, illiteracy and ignorance of the worker and absence of leadership from the rank and file. Thus, the primary idea behind the establishment of such bipartite committees are giving encouragement to the parties concerned to settle and compose their difference by themselves in order to avoid the direct interventions a third agency and facilitating the composition of the difference at their embryonic stage without causing work stoppage. Okay. As the state encouraged and required the establishment of bipartite committees for the purpose of composing grievance and difference between workers and their employer, it may also think it advisable to encourage and, if necessary, to force workers and employers to enter into formal collective bargaining through their representative. The idea behind such a policy is to force the parties to seek to settle their difference through mutual negotiation, and this discussions before they decide to resort to strike or lockout, where the parties themselves have set up a machinery for collective bargaining and negotiation. The impositions of collective bargaining by the state become unnecessary, where the parties themselves have set up a machinery for collective bargaining and negotiation. The imposition of collective bargaining by the states become unnecessary, but if either of puts the party resists the establishment of collective bargaining and the state feel that collective bargaining helps the peaceful and democratic conduction of industrial relation, it may impose collective bargaining compulsory. It was in this frame of mind that the federal government of the United States under President Roosevelt enacted the National Labor Relations Act 1935, popularly known as the Work Act. This act made the refusal by the employee to bargain with the representative of his employees an unfair labor practice and imposed penalties for the same. This act made the refusal by the employer to bargain with the representative of his employees an unfair labor practice and imposed penalties for the same. The Labor Management Relations Act of 1947, commonly known as the Taft-Hartley Act, made the refusal to bargain either by the employee or by the trade union an unfair labor practice, known as the Taft-Hartley Act. Made the refusal to bargain either by the employee or by the trade union an unfair labor practice. Okay, about conciliation and mediation, the third method used by the state for promoting a peaceful settlement of industrial dispute is the provisions of conciliation and mediation service. There is no essential difference between conciliation and mediation, and the two terms are used interchangeably. The means conciliation and mediation is a form of settling conflict in which an outside agency or person is used as a go-between by the contending parties. The agency or the person endeavors to help the disputants arrive at mutually acceptable settlement. The role of the conciliator or mediator is limited to one of counsel and advice. Okay, next about key point on conciliations and mediation is voluntary conciliations and mediations. Under the method of voluntary conciliation and mediation, the state set up conciliation and mediation machinery consisting of personnel trained in the art of conciliating disputes. The service of the machinery are always available to the disputants. Whenever they feel that the conciliator may help them in resolving their dispute or in breaking a deadlock, they may call upon the service of the conciliations machinery. The aim of the conciliator is to break the deadlock if any explain the stand and the viewpoints of one party to the other, convey a message, and generally keep the negotiations going. Suggestions may come from the conciliator or the mediator, but the parties are free to accept or reject them. It is the parties who ultimately decide the issue. They may or may not come to an agreement. This sort of conciliations or mediation is not different from voluntary collective bargaining and may be said to be more continue of the process of collective bargaining. Okay, next about compulsory conciliation and mediation. In many countries, the state does not rest content with the more creations of a conciliation service. It imposes an obligations on the parties to submit their disputes to the conciliation service and make it a duty of the latter or to seek to conciliate the dispute. Meanwhile, the state requires that the parties refrain from causing any work stoppage for the purpose of resolving the dispute so long as the conciliation proceeding is going on. There are three main considerations for prohibiting the party from causing work stoppage and imposing this time limit. Firstly, it is a fact the conciliation will provide a cooling off period during which emotional tensions may subside and a settlement can be arrived at. Secondly, it is felt that the freedoms of the parties to settle their dispute even by causing work stoppage should not be taken away from them for a long period. Thirdly, it argued that if conciliation does not achieve an early breakthrough, it is not very likely to success later if at the end of the conciliation proceeding the parties fail to settle their dispute. They are free to go on a strike or declare a lockout. But the state may further persuade the parties and use other methods for bringing about the peaceful settlement of the dispute. Okay, about compulsory investigation, another method of interventions by the state in the settlement of industrial dispute is compulsory investigation of the implication of a particular dispute. Many governments have assumed power under law relating to industrial relations to set up a machinery to investigation any disputes. The purpose behind the appointment of a court of inquiry is essentially to find out the relevant facts and issues involved and to give them wide publicity so that the pressure of public opinions may force that recalcitrant party to give up its obstinate attitude. The second purpose behind the appointment of a court or board of inquiry where strikes are prohibited during the preliminary investigation as the United States is to provide a cooling off period of the parties concerned so that they could reconsider their respective stand, realize the implication of their step, and if possible settle their dispute peacefully. Okay, the last slide, a legal requirement that empower the government or prescribed authority to refer an industrial dispute to an injunction authority whose decision is generally binding on both the parties and also on those affected by the dispute. The main idea behind the imposition of compulsory arbitration is the maintain industrial peace by requiring the parties to refrain from causing work stoppage and providing a way for settling the dispute. The following are the two principal forms of compulsory arbitrations based upon the nature of reference and nature of the award. Second, compulsory reference but voluntary acceptance of the award. And second, compulsory reference and compulsory acceptance of the award. Okay, that's all.
Assalamualaikum warahmatullahi wabarakatuh. My name is Nurul Izzati binti Muhammad Rozi, Nometric I18102823. Okay, I will continue to present this chapter. Okay, next is about adjudication, compulsory arbitration versus collective bargaining. Okay, the foregoing comments necessitate a discussion and critical evaluation of compulsory arbitration. It is also necessary to compare it to its only alternative, collective bargaining, and to find out which one of these is best suited to the needs of the peculiar economic and political situation that prevail. The argument for and against compulsory arbitration can be discussed under two needs, which is one, argument relating to its principle, and second, argument relating to its practice. Okay, adjudication compulsory arbitration relating to its principle, support of compulsory arbitration content that adjacent coercive thought it may be it superior to collective bargaining. Collective bargaining settle a dispute on the principle of trial by combat. Okay, next is relating to its practice. Collective bargaining may be democratic, but it endangers industrial peace. Therefore, compulsory arbitration has to be used for the purpose of resolving industrial dispute. Okay, for collective bargaining, that relating to its principle, the main argument against the principle of compulsory arbitration is that it leads to an authoritarian imposition of the terms and conditions of employment and suppress the possible self-governance in industries based upon the democratic freedom of the parties to resolve their dispute through collective bargaining. While when it's relating to its practice, it involves long delays and heavy expenditure, which put the trade unions in a comparatively disadvantaged position. Compulsory arbitration has practice in India at present depends in most cases upon the reference of a dispute that the adjudication authorities. That's all from me. Thank you.
Assalamualaikum warahmatullahi wabarakatuh. My name is Siti Mazliminti Muhammad Rijal and my matric number I181028887. Okay, today I would like to present about the procedure for the settlement of a trade dispute. Okay, the first one is a labor court. The National Labour Commission also proposed the establishment of the permanent entrusted Labor Court, the function of interpretation and enforcement of all labor laws, awards, and agreements. Okay, this court is for dealing widely with the dispute relating to the matters in the second schedule of the Industrial Dispute Act 1947. Labor court are required to entertain proceedings initiated by the parties requesting for the enforcement of their right and to execute the same as the appropriate, and appeal against the decision of the labor court in certain clearly defined matters may lie with the High Court. The appropriate government may constitute one or more labor court for the adjudication of the industrial dispute relating to any matters provided in the second schedule of the Act and performing such other function as assigned under the Act. Okay, the second schedule include number one is the propriety or legality of an order passed by an employer under the standing orders. Number two is the application of the interpretation of standing orders. Number three is a discharge or dismissal or workman, including reinstatement of or grant of relief to workmen wrongful dismissed, and the last one is a withdrawal of any customary concession or privilege. Okay, the second one is a tripartite. Okay, the commissions commended the role of a tripartite bodies in involving uniform norms in the field of the industrial relation in the country. An industrial relation dispute is a difference of opinion resulting in a dispute between employers or an association of employers with the workers or trade unions. There may be a disagreement on rights, conflicting interests, a dispute over termination of employment, or a dispute among trade unions within the one enterprise that could be caused by differences in implementation or interpretation concerning the law and regulation, work agreement, company regulation, or the collective bargaining agreement. The employer of the trade union, which is a party to the trade dispute, may submit a complaint to the department for the purpose of seeking a resolution. Okay, there are three steps. Number one is a negotiation. Negotiation will be carried out between the trade union and the employer according to the procedure stipulated in the collective agreement or in accordance with existing company procedure or policies. Okay, the number two is a conciliation. If a resolution cannot be achieved through the direct negotiation, the trade union or the employer may report the trade dispute to the nearest industrial relation office. If a resolution is still not attained, the trade dispute will be forwarded to the Minister of Human Resources, who, if he thinks fit, to refer the dispute to the industrial court. And the last step is the arbitration by the industrial court. The industrial court will hear and decide upon the issue in dispute referred to it by the minister and issues an award. The decision of the industrial court is binding on all parties involved, and it is final and conclusive. Okay, that's all from me. Thank you.
Okay, Assalamualaikum warahmatullahi wabarakatuh. My name is Nur Shahira binti Zaidan. I 1810231. So now I want to just make a summary conclusion about our chapter. So what we learn from this chapter? So we learn about the method of settling industrial dispute without state intervention comprised. So we have two. First is collective bargaining and second is voluntary arbitration. So the method of settling industrial dispute with state intervention include: first is compulsory establishment of biparty committees. Second is establishment of compulsory collective bargaining. Third is conciliation or mediation. Next is compulsory investigation, and lastly is compulsory arbitration or adjudication. So, collective bargaining is a process of determining the specific terms and conditions of employment of workers by direct negotiation between the representative of one or more union on the one hand and employer or association of employee on the other. So the advantage of the collective bargaining include enabling the parties, providing opportunity, and ensuring acceptability and conducive the establishment, elimination, and lastly is uncertainty in the resolution of dispute. So the voluntary arbitration is the procedure voluntarily chosen by the parties to an industrial dispute whereby the dispute is settled by an impartial arbitrator or umpire of their own mutual selection. So conciliation or mediation is a form of settling industrial dispute in which an outside agency or person is used to go between by the consenting parties. So the agency or the person endeavors to help the disputants arrive at a mutually acceptable settlement. So the adjudication or compulsory arbitration are involve a legal requirement that empower the government or a prescribed authority to refer an industrial dispute to an adjudication authority usually known as tribunal Court of Arbitration, Labour Court or Industrial Court, whose award is generally binding on the parties. So, the adjudication or compulsory arbitration involve a legal requirement that empowers the government or a prescribed authority to refer an industrial dispute to an adjudication authority, usually known as a tribunal, court of arbitration, labor court or industrial court, whose award is generally binding on the parties. So the main advantage of adjudication as a method of settling industrial dispute are first is ensuring element of law and justice in the resolution of dispute. Second is helpful in the growth of industrial jurisprudence. Third is control of work stoppage. Fourth and lastly is consideration of the interest of the community. So the statutory machineries for the settlement of industry in India include: first is work committee, conciliation officer, board of conciliation, labor court, tribunal and national tribunal, and grievance redressal committee. So the first National Commission of Labour is in 1969 recommended the replacement of the existing ad hoc conciliation and adjudication machinery by permanent industrial relation commissions at the national and state level. So that's all from our group for this chapter. Thank you.